Hello everyone, welcome to Legal Darshan. I hope you all are doing fine. In today's video, we are going to discuss about the PoSH ACT, which is the Prevention of Sexual Harassment Against Women at Workplace Act 2013. The cases of Vishakha versus State of Rajasthan and Megha Kotwal versus Union of India have been the pioneer cases in bringing out the evil of sexual harassment against women at the workplace. The series of these cases gave rise to an exemplary statute, PoSH Act of 2013, which we are going to discuss about in this video, which is also known as Prevention of Sexual Harassment at Workplace Act 2013. The act is primarily based on Vishakha guidelines directed by the Apex Court in 2005, but since they were not practiced properly, a new legislation with confirmed provisions was brought into the picture. So, what exactly is sexual harassment at workplace? Who is an aggrieved person? Who can be called a victim? What is a workplace? We are going to discuss about this in the video. Section 2 of the said act defines various terms. An aggrieved woman is the woman in relation to a workplace of any age, whether she is employed or not, whether she is on a muster roll, whether she is a contractual employee or whatever, or in whatever way she is associated with the workplace. If she has been subjected to sexual harassment by fellow employees or employers, she will be said the aggrieved woman. The section 2N of this statute defines sexual harassment as an act or series of acts of unwelcome nature, whether directly or by implication, namely physical contact and advances, a demand or request for sexual favors, making sexually colored remarks, showing pornography, any other unwelcomed physical, verbal, or non-verbal conduct or gesture of sexual nature. Now, what is the workplace for this act? The workplace could be any establishment, undertaking, department, authority of government, private sector, hospital, school, institute, dwelling places or houses, construction places, or at any place where a female employee has been posted for the course of employment. Section 3 of the said act also lays down that no women at workplace shall be subjected to sexual harassment. Following are the circumstances if connected with any act of sexual harassment may also lead to sexual harassment. Implied or explicit promise of preferential treatment, implied or explicit threat of detrimental treatment, implied or explicit threat about her present or future employment status, interference in her work and creating hostile work environment, humiliation as to her health and safety. If these acts are conducted on behalf of employees or the employer, then these will also amount to sexual harassment under the PoSH Act. Now, how can this be cured? For this, the statute has provided two committees. One is Internal Complaints Committee, which is established between the organization, and another is Local Committee, has to be formed in all the districts for the regulation of provisions of this act. Section 4 talks about the Internal Complaints Committee, which is also called ICC. Every employer in written shall constitute a committee at all the branches of his office. Now, who can be members in the internal committee? The presiding officer of this committee is a woman who is at senior level at workplace, and if she is unavailable, a woman must be nominated from another branches of the same office. And if this is also unavailable, from some other workplace of some other employer or some other organization, a female senior officer can be brought to make her the presiding officer of Internal Complaints Committee. Half of the total numbers of the committee must be women. One member must be dedicated to the cause of women, and not less than 2 members of the committee must have social and legal knowledge. The tenure of presiding officer is 3 years from the date of her nomination, and the members of the committee are paid allowances for their proceedings. How can they be removed from their positions? If they are convicted for an offense, if they are held guilty in a disciplinary proceeding, if they have abused the position in continuance to prejudice the public interest. Section 6 and 7 talks about the local committee. Every district officer shall constitute in district a local committee to receive complaints of sexual harassment from establishments where ICC has not been established due to less than 10 workers, or if the complaint is against the employer himself. One nodal officer is required to be appointed in every block, taluka, tehsil, ward, etc. to receive complaints and forward them to the committee within 7 days. The presiding officer of this committee is the woman who is eminent in the field of women rights. There is one working woman in the block, ward, taluka in the district, 2 members from non-governmental organizations, out of whom one must be women and both must be committed to the cause of women. There must be 1 woman in the committee belonging to oppressed castes such as SC, ST, OBC minorities, etc. The concerned officer in the district for social welfare or for women and child development is the ex officio member of this committee. Now, how can the aggrieved women file the complaint against sexual harassment? It has been provided in Section 9 of the Act. The aggrieved women may make a complaint to ICC established at workplace under Section 4 and to the local committee if ICC is not constituted within a period of 3 months from the date of incident or from the date of last incident if there are a series of incidents happening with her. The complaint is to be made in writing, and where the complaint cannot be written, the members of the committee are required to assist the women in all the possible ways to get it written by her. The committee may record reasons in writing and extend the time limit if the committee is satisfied that there were some serious situations stopping her to file the complaint, provided that the extension cannot exceed 3 months. When the aggrieved woman dies due to physical or mental incapacity, in this case, her legal heirs may file a complaint under this section. Section 11 talks about the inquiry procedure. When the complaint is filed, the committee may look for the prima facie case to bring it under Section 509 IPC 1860, which is outraging the modesty of women. The inquiry has to be completed within 90 days. The committee has the power to try the suit and summon and enforce the attendance of the accused to examine him on the oath, require the discovery and production of documents, and try any other matter which may be prescribed. Section 12 of the Code provides that during the pendency of inquiry, the committee may change the workplace of aggrieved women or grant leave to the women. Section 15 of this Act determines the compensation to be given to women, which has regard to the income status of the respondent, the trauma and mental expenses suffered by the aggrieved woman, and the mode of payment, etc. So, if any known person of you undergoes the sexual harassment at workplace, this statute makes sure that the accused person is punished, that inquiry will be conducted against the person, and if found guilty, there are compensations and punishments. This was all for today's video. I hope you liked it. For any queries, suggestions, information, etc., please feel free to contact us at legaldarshan@gmail.com. You can also drop the feedbacks in the comment box below. Thank you for watching this video. Please like, share and subscribe. Have a good day.